I think we are live now. This is good. So thank you very much, everyone, for joining us today. I'm very happy to be chairing this webinar, the fourth of the series from DigNA webinar series. Very happy to welcome two fantastic speakers today here, Robert Harrison and Lluís Gimeno-Fabra. I'll just do a quick introduction very shortly. But before that, just a quick housekeeping, information that we are recording the meeting and will be shared on various media platforms from the DigNA portfolio project members and so on. If you have any questions or requests, you can also contact Robert Grass. I guess the information will be provided also via the message board. And so we have two presentations, two speakers, and we'll have 45 minutes for the presentations roughly, and then 50 minutes for question and answers. So please use the Q&A box to ask your questions, and I will just relay these questions then to the speakers at the end of the webinar. So I'm going to just first introduce both speakers. I'm going to start with, breaking the tradition, asking a question first to each of the speakers, and then we'll go straight to the presentations. So I'm going to start with Robert Harrison, who is a European patent attorney recognized by the Managing Intellectual Property and IEM Patent 1000 as a leading practitioner in intellectual property law. Who is also advising many research institutions and technology companies on innovation strategy, patent portfolios, technology transfer, and he has a particular focus on bioinformatics, advanced materials, and related emerging technologies. So thank you very much, Robert, for joining us today. Looking forward to your talk later on.
Thank you.
And the other panelist is Lluís Gimeno-Fabra, who is an advisor to the Vice President Patent Granting Process and Team Manager in the European Patent Office, EPO, which he joined in 2007, following several years in aerospace technology transfer. Among his other duties, he supports the EPO Observatory on Patent and Technology in the coordination and execution of its far-reaching working programs with European institutions, with emphasis on strategic patent intelligence. So this is it. So this is the fantastic panelists we have today. And I'm going to start with a very quick question, because of course, we are, that's part of the EIC Pathfinder, DigNA portfolio projects here, which, I'm chairing the working group for, which is looking at, protection and exploitation. And of course, one of the first questions you ask when you have, an early stage, perhaps startup. So why is it important to strategize IP? I mean, IP is important in itself, but why is it also important to have a strategy when you have IP? And perhaps ask Robert that question very quickly and answer for that.
A brilliant question, actually, one that's often asked. Patents, of course, are not designed to be publications that recognize scientific excellence. There's other medium for doing that. Patents are designed to actually recognize and help you implement business strategies, so that you need to be thinking about how do you actually match your business strategy to your IP strategy. And we'll go into that in a little bit more detail in my short presentation.
Fantastic. Looking forward to this one. And now another question for Lluís, perhaps. So how can the EPO help in this context, with a young startup, just, trying to leverage on perhaps some IP and or even just deciding where to file a patent or so on. So how can the EPO help with this?
Well, it's a very broad question, Jerome. And the EPO, it has a very broad range of measures also to support directly SMEs and micro entities. I will post some links afterwards in the chat that the beneficiaries can see them. But what I think is more important for the meeting today, which concerns fundamentally a portfolio or program, the DNA digital storage program of the EIC, is that the EPO has developed a methodology to landscape the IP, let's call it the patent situation to be more precise, the patent and technology situation around one particular program of the EIC, and to give it to you as program managers or as the responsible for the valorization of the IP, that you understand in which landscape, in which context are you operating, and help you reflect, help you ask the right questions in view of, in the following years, Pathfinder has relatively low technology readiness levels, so that so that in the road to commercialization, you are sure that you have the right backup from IP in general, patents in particular.
Fantastic. And I guess we're going to dive into that directly now, this patent cartography, which is the topic of your presentation now. So
Yes.
The floor is yours, Lluís. Thank you very much, and looking forward to
Good.
seeing the presentations.
I think now we will be bound to the sharing technology. Perfect.
Now it's good.
So
thank you.
Thank you very much. This presentation will be shared. It's a presentation that in principle is available to all of you in extended format, so going really into very granular detail, but we do not have the time, of course, to go into this detail today. The DigNA digital storage portfolio is a very, frankly, it's not just a polite statement, it's a very special one for us, because with your program manager, with Isabel, this was the first mapping that we did. And the first mapping that you received was made using the pilot methodology that involved a lot of human interaction. So in this presentation, what I will give you now some indications of the new ways of doing cartographies by the EPO, applied that we reapplied, of course, to the DigNA digital storage portfolio. And then I will not go into the granular content that you have, but I will give you some indications or some interpretations of the results that we found. So what is a cartography? Well, it's a methodology that should not be, and I emphasize it, confused with patent searching or with freedom to operate studies. It is not concretely applied to a given set of claims, for example. It's a methodology that allows us to flexibly scope selected areas using any form, any input information that we can receive from, for example, the EIC, CORDIS, project specifications, public information, but we can also operate with confidential information. And what you do not know, because this was not applied to the DigNA digital storage portfolio when we did the cartography at the beginning, but we have applied it now, is that we are using large language models to structure all of this information, feed it into our internal patent and non-patent literature search systems that index about 350, 400 million documents, and create business relevant statistics that you, with the help of someone like Robert, can interpret, so that you can ask the right questions to generate an IP strategy. What is the type of information that you get? Who are the main actors? Which you can proxy. It's not the same thing, be careful, but you can proxy to who are the owners of those technologies, and where is innovation happening. The relevant patent literature, that's what PL stands for, and lately we have incorporated non-patent literature and standard citations in the area, not perhaps that relevant for DigNA digital storage, but extremely relevant for example, telecommunication areas. The geographic distribution, so as a proxy to where are the technology markets, but also how are they behaving. You will see that in DigNA digital storage, Europe in particular is becoming a central patenting area for American and Asian large corporations, which has implications in your IP strategy. Robert will speak more about this later. But also we start to proxy what is the legal status of potentially active patent rights. So are there active patents around, or is it just pending or even withdrawn applications, and the time threats. You know, just that you get the full pictures. DigNA digital storage is the first one. We've finalized and are on maintenance for health continuum, quantum, cancer genomics, and cell gene therapy, and ongoing with other portfolios of the EIC. How do we do this? As I was saying, we input any form of information into an LLM interface that is operated by real experts on your technology, on DigNA digital storage in particular. We have one of the finest taxonomies in the world at the EPO with 4,000 examiners. We generate a library of concepts that correspond to, hopefully, to the areas that are relevant to your projects. And then using Ansera, it's what you see at the right of the screen, we find what are the most important patent and non-patent documents in those areas. And then second part, we generate the business relevant statistics that I will show you around. Now, I will not speak much more, but let me give you some general results on the DigNA digital storage where you can dive in as much as you want afterwards. It's a booming area. It's an emerging area. We know that. We are not surprised. I mean, this is, of course, what we generally find in the EIC programs. It's real emerging areas, which means also that they have been, I know that there is no pre-selection as such, but that they are on the right technology areas because they are the big growing ones. In our mapping, in our cartography, we found out that there are about 1,821 families, including about 700 international ones, meaning seeking protection in several geographic areas, basically the United States, Europe, and Asia. And that in your specific areas, we have, let's call it a higher than normal. I do not want to benchmark with other portfolios, but a higher than normal share of United States companies, followed by China, Japan, and some European companies. We'll see it in 1 second. We also see that it's an emerging area, and this is something that is very typical. We've seen it in other portfolios, also in Quantum that we presented last week, because roughly one fourth of the international patent activity in the area corresponds to, let's say it roughly, don't take it as black and white information, to 20 applicants. When the areas are more mature, we see that the share of the top applicants is increasing, which means that there is also a lot of opportunity for consolidation still. The taxonomy that we used is has several boxes or drawers. Level 1 obviously is the title of your portfolio, DigNA Digital Storage. And level 2 are the 4 main drawers. In part, you will find them in Robert's approach: bioinformatics, storage of information, wet chemistry. And then in the level 3, you find a much more refined taxonomy. And of course, for each of these levels, and we call them drawers internally, what you will find in the more detailed information is an analysis of activity. Let me just give you the general one. This is what you see in terms of trends, and in particular this rise I was talking about since 2013, consistent rise. You see here that not all of the areas are equally active. In particular, bioinformatics, wet chemistry are the ones where we've seen an increase lately, or we've seen a consistent increase. I know that wet chemistry, there is a decrease, but when you come close to 2024, 2025, one has to be careful because of the way that patent data is structured with over-interpreting information. And I think that this is where I will want to end. This is where you see here where the top 20 applicants are, this distribution. They told me, which I didn't know, that I can zoom in so that you can see a little bit more the names. But of course, what you see is a preponderance of large US corporations, with European corporations coming at 6th place in the present case. You see also something which is very interesting, and what we have seen in other portfolios, that large US universities do structure very powerful IP portfolios, which also has implications. They almost behave, let's say, like corporate entities in this sense. And well, would we go, which we will not do now, deeper in the presentation, where you could see is this type of information for each of the drawers, where you hopefully recognize the technologies that are relevant to your specific projects. And now that's where the moment also of us as an institution have provided the landscape, and it's up to you as a portfolio to define the IP strategy that you consider more adapted to this landscape. I hope that I've been not too long, but comprehensive enough.
Okay, fantastic. Thank you very much, Lluís.
I'll stop sharing.
For the presentation. So yeah, we're gonna switch on directly to the strategy aspect with Robert now, if you don't mind. Thank you.
Yeah, so thanks very much indeed. I just sort of bringing up my presentation here. It's absolutely fascinating to sort of listen to read this. I've been privileged to actually have seen that presentation a few days ago, and so I've been actually looking through it. It's been absolutely fascinating. And so Lluís and I prepared the two presentations slightly differently from each other's, but it turns out that I think we've done some quite interesting overlaps. So I'm not going to bother too much about the first couple of slides here, which is just the basic agenda, and I thought was quite useful to do it. You all know who I actually am on it. And I think one of the things that we start needing to think about when we're strategizing is not just filing a random number of patents in any direction when we suddenly have a good idea, which you might have done when you were working at a university or in a research lab. But what we're trying to actually think about is, where are the areas in which you should really be thinking about filing patents? So these are the areas, for example, which could be the core bottlenecks within the DNA storage say ecosystem. Can you actually prove the ideas that you've got? I mean, is it actually visible to the outside world? Does it provide them more efficiently? How good are the algorithms and the codecs? And also, we talk a little bit about the wet chemistry here, as Lluís has done, and I can thoroughly recommend you read his presentation in full when it's published the next couple of days of time. But I was thinking when I was preparing this presentation, what are the actual steps that you do within DNA storage? And obviously, this is a little bit on the left-hand side here, a little bit simple. But it gives you a pretty good ontology of where you should be working and what you should be thinking about doing. So some of you are specialized very much in the synthesis, in the wet chemistry, for example. And that's where you would probably focus the majority of your patent applications. Okay, you might have an interesting encoding idea, you might have an interesting sequencing idea, but it's probably worthwhile actually really focusing on what is going to be your core technology, where you think people are going to be wanting to work with you in the future. And so one of the things I'm often doing with companies, when I'm working with companies, is getting them to categorize the patents. Some people use the EPO's cooperative patent classification to do it, but my impression is that that's probably a little bit too complicated for the majority of small startup companies, and that you should be really thinking about what your own ontology is and how it could actually work out. And as you saw an example with Lluís's presentation, how they're doing it at the EPO. That's great, but you don't have to do it like that at all. Just work out what you want to do, where you want to do it, and get this ontology right, so that if you think you're really working in synthesis and presentation, you want to have a balanced patent portfolio in those areas. And so let's start thinking about that in those various terms. Now, throughout the rest of this presentation, I'm going to make the assumption that you understand the basics of patents, that the patent has to be new, it has to be novel, and it has to be inventive at the end of the day, and industrial applicably, but I don't think we need to worry too much about that there. So we're not going to go into that and the various fine details on that. We're really going to be looking at how to strategize where you start from here. Lluís has talked a lot about patents. He works for the European Patent Office, as I did many, many years ago. But actually, intellectual property protection is more than just patents. Intellectual property protection is a lot about copyright, particularly software is copyrightable. It's a lot about keeping trade secrets, that knowledge that you've got inside your head. In my PhD days, the original things that I learned when I was doing my experiments didn't come from reading books, reading patent documents. They came from talking to the postdocs. They came from talking to the other PhD students. And those are trade secrets, as we call them, that you really want to keep inside your head, or secret, not published. And the classic one is one that, if you can look at some of the EPO stuff, for example, they talk about the Coca-Cola secret recipe stored in Atlanta. more for you is probably going to be some of those tricks that you're using in wet chemistry, for example, some of the ways and some of the codecs where you realize that actually there's a certain way of processing it which you don't actually want to tell the rest of the world when your documentation. That's the thing that you should be looking for. And then obviously we're talking about DNA storage of data. Well, data itself maybe technically is not an intellectual property asset. Some people would argue, yes, it is. Some people would argue it's not. But it's certainly something that you need to think about on how this should be protected in the future. Now, one of the things I'm often talked about is, computer programs not patentable under the European patent law. Well, yes and no is the answer. It's quite clear that a pure computer program is not patentable. Sort of all that lines of code that you've written tends to be a little bit more patentable in the United States. But actually, within Europe, as long as you've got the technical application, and DNA storage does mean technical application, you shouldn't worry so much about it, you can actually get patents provided. Now, the one I've got here is actually a US patent because I found it was one of the most easiest ones to actually understand here. They didn't file, this one is from, let me just check, sorry, I'm hidden, it's behind here. So this one is actually from Lenovo. They didn't file a European patent on this, but it was actually been granted in the United States. And it's one that I certainly think would be granted in Europe if it was had it actually been filed in Europe. And you'll see very much the structure of the patent, what they've decided to do with Lenovo. Lenovo is obviously an ICT company, so they're not going to be focusing so much on the wet chemistry behind what is going on in the DNA storage. For Lenovo, it's much, much more important to sit down and think about how the computer actually works. And here we see we have a computer, well, they call it a system, and with one or more processors, and obviously a memory, and a lot of the beginning of the patent application is a little bit blah, 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 nothing really particular there. But then they sort of go down in this last section, this last half, where they've really got the core of what they see to be the most important aspects of it. This patent was only just recently published in 2025, and it's based on one that was filed back in 2023. Personally, I might have a doubt whether that patent is valid or not, but we do see that the US Patent Examiner reviewed that patent in detail and has issued this patent. You need to treat it, if anyone's working in this field, you will need to treat this as a valid patent, particularly if you're going to be selling services or selling apparatus into the United States. There is nothing on this patent claim that we have here, which is the legal protection about wet chemistry. This is purely, at the end of the day, an ICT patent related to patent about it. But what we're seeing here is something that we know will be accepted by at least the US Patent Office, and I'm pretty certain would have been accepted by the European Patent Office as not just being a computer program, but actually really adapted to the concepts of DNA storage. So my next one that I wanted to show you is talking a little bit about this relationship between trade secrets and patents, particularly with respect to codecs, because I'm often hearing, well, we don't actually provide the source code, or sometimes you do provide the source code as open source. So is it really worthwhile filing the patent on it? Well, we've just seen here that Lenovo have filed a patent on it. And it's actually quite challenging to keep computer code or the instructions within computer code totally secret these days. Yes, you might not have the tools to actually work out how the computer is working, how the code is working. But I can tell you there's some very, very good organizations out there that can actually reverse engineer an awful lot of what is going on here. So what we do know when we're thinking about whether it's worthwhile filing as a trade secret, you really need to think about, could somebody reverse engineer it and therefore get how it actually worked or not? And if they cannot do it, then I would certainly consider it as a trade secret. But on the other hand, if the codec at the end of the day can essentially be decoded, which I'm pretty certain that you would be able to get it from this particular patent application, then maybe you will think about filing as a patent. But of course, that does mean that you need to reveal what exactly you're doing. And again, I can urge you, people working in it, to have a look at this patent application in detail, because it's quite well written and explains exactly how they're doing it. One of the things we're always thinking about as patent attorneys is, can you actually enforce the patent application? Can I actually prove that somebody is enforcing or somebody is using my patent application? Now, we don't go to court most of the time. You know, you hear about these massive cases, Apple against Samsung, Microsoft against other companies, currently Daimler-Benz against a few other companies in the car sector. Yes, those are the ones that really hit the publicity. Most discussions about patent applications, about patent infringement, happens in negotiations between two companies. And sometimes companies accept that they might be infringing a patent, and there's an agreement either they move away from what they were previously doing, or what they decide to do is they then decide that they want to have a negotiate a license. So that's something that we really need to be thinking about. And that's one of the reasons why people who say, well, there's nothing in my field, I don't need to worry about it at all. Well, you don't really know what's going on under the hood. You don't really know what's going on publicly at all. The last thing I want to talk about is duration. So we know patents last for 20 years from the date of filing. Trade secrets can be kept indefinitely as long as they are kept secret, and it's important to keep them secret, by the way. Then the moment they become non-secret, you can never enforce them at all, but potentially they're unlimited. I just refer once again to the Coca-Cola recipe. Though between you and me, I should be honest, apparently it has actually been published in the meantime. So one of the things that we need to be thinking about when you are filing a patent is this concept of the inventive concept here. And the way that we try and treat it in Europe, and essentially most of the rest of the world, is we start sitting down and thinking what the problem is and what the solution that you have actually created. And it's really thinking about that solution, not just thinking in abstract terms, but thinking about the problem that does and the solution that you do, and then sitting down and thinking, are there non-conventional features that are really, really going to help me? That is what is going to give you the really strong patents, when you can map these non-conventional features to what is going to give you the business advantage. So that if you can say, well, this potential codec that I have here is much, much more efficient than anything else that I've been able to see in the past. And I know that it allows much more effective coding, much more efficient decoding of the information, and then writing that into the patent as the most effective way of getting a patent. Because what that then means, if you're marketing, people are saying, this is what we are doing, this is why you should be using us. That could be marketing to customers, but it could also be marketing to financial authorities, to your venture capitalists, for example. That gives you the strongest patents. And you really need to be thinking about how we can actually match this and move together on this. So let's talk a little bit about another example, an apparatus. And this was, so we saw a codec previously. This is written very, very similarly. And this actually comes from another US company, I'm afraid. It's pending in Europe at present. The reason why I've got a couple of US ones is because they just were very, very simple to actually understand. Some of the European ones were quite complicated. And again, what we're seeing here, again, it's a patent that comes from 2021, was granted in 2021, but if you look back here, it goes back actually all the way to I think, but here back to what's that? I can't really read it at this stage, but back into the mid 2010s. So what we're looking here is that we've sat down, the company that did it, and actually sat down and thought, how am I going to protect this? Where is the core invention of it? And if we go down, we can, whoops, sorry, I skipped on this one. If we go down here, we start seeing again, blah, blah, blah at the beginning. That's quite common, this preamble. We just put a little bit of information. We give the examiner, we give the reader of the patent application, a background to actually understand. But it's normally the last few features that are really important to actually understand what the inventive concept is here. And we see here that they're very much focused on the sensor comprising a pair of spaced apart electrodes and a molecular complex attached to each electrode to form a molecular electronic circuit, etc., etc., etc. One of the nice things about European patents, and some of you will have seen it, is this word characterized by that you find it. And everything below that characterized by represents the novel concepts or the inventive, the non-conventional concepts that you actually have here. Unfortunately, in the United States, they don't have that convention that we often use in Europe. So it's sometimes a little bit more challenging to actually understand what's going on. But we see the company that filed this really thought that its last two bullet points on this patent or claim was what it really needs protecting. So I know some of you are actually more into wet chemistry. Couldn't really find a good, really understandable patent application in wet chemistry. This is, granted patent in wet chemistry, but this is one that, again, it's comes from the United States here, very, very easy to understand. It's still being examined. The most important thing is be careful. Is you got a granted patent, or is it examined? Is it been granted, or is it still being examined by the applicant? So you remember going back to Lluís's presentation, that last slide he showed, there were two colors on those bars. And what he really said is, I think the first elements are those that are still being examined, and those that, the first ones were those that have been granted, and those that were still being examined. And we saw that there was obviously a lot more still in the examination process. So just look at this. It does actually quite clearly say application publication. So we know this has not yet been granted. But this is where the company here, comes from Illinois, really feels that it's got an interesting, potentially novel idea for actually doing the DNA storage elements. I don't know. I haven't gone into this in any detail. It is actually possible to go into the data files of the Patent Office and see the discussion between the patent examiner and the applicant to actually really understand, has the Patent Office got some really interesting prior art which would knock out the patent, which would invalidate the patent or kill the patent, as we sometimes say, or not. This one, as I say, this is where they have decided, which is where their real focus is. And particularly, it's some people file lots of patent applications and, accept that the Patent Office is going to reduce the scope of the patent. That's sometimes not a good idea, because you can sometimes spend an awful lot of money doing something like that. It's a really good idea to actually sit down in advance, use some of the tools that the European Patent Office can provide to you to work out what has already been done in the past and where our non-conventional elements really provide the business value to what we are doing. So one of the issues about DNA storage is the question of whether they can be protected, because, we know DNA is all around us. I mean, our bodies have DNA in it, in a sense. And there's some really quite clear rules that have now been established by the patent offices. Firstly, a naturally occurring DNA molecule cannot be patented per se. People have tried. There's a patent application, I think, in the UK, where somebody's basically said, I want to patent my body. That is not going to accept. Any naturally occurring material cannot be patented per se. That doesn't necessarily exclude the application of the naturally occurring materials, because if we didn't allow patent protection for applications, we'd actually lose quite a lot of patents for very valuable, very, very valuable patents for medical devices, for example, for treatments of matter. There's a bit of an issue in the United States on this at present, which I won't go into at present, but just think about not naturally occurring. If, on the other hand, you produce a DNA storage system where you're not necessarily using a naturally occurring molecule, where you have described in detail in the patent application how that molecule is created, the synthesis on it, you will be all right, because it then comes into what's called a composition of matter in the United States. Again, they have a very strict rules about it, but something like that would be certainly patentable in the in Europe. And for those of you really working on chemical synthesis, what you would be thinking about is actually thinking about, how can I patent that molecule? How can I get a patent that looks something like this, for example? What's the novelty? Is it in that structure? Is it the attachments that I've got to that structure? Again, you read that patent application. It's beautifully written to describe how their attorney thought about doing it. So one of the things I really wanted to talk about in just the last couple of minutes here is data rights and ownership, because working in the DNA storage area, you will be having to start thinking about some of these data rights. At least some of you will have to be thinking about this and thinking about the source data. The rights to the source data is actually retained by the customer. What about the derivative and the usage data? Who actually owns the DNA molecules that you're storing? An interesting question. Is it a custodian? Is it you own it? Something that will need to go into your terms and conditions of business. But one of the things that working in this field I've seen is people need to think about the EU Data Act, which clearly says you don't have any vendor lock-in. You've got to really think about how you are going to provide access to the DNA data without without having access to the original vendor or to the original person who needs to decode it. And we'll come to that one point in a moment about standards that are being established in the DNA storage area. But it's really important on this, and as some of you, and I think you know from the EIC, was one of their aims was to work out how to be able to avoid vendor lock-in, and it quite clearly says it's in the EU data access. The other point about it is no access to data by non-EU governments. Again, that is something that you're going to have to seriously think about when you're using some of these areas. If you're doing everything in EU and EEA countries, and I know there's a few people in Switzerland, I'm not entirely certain about what the Swiss rules are, but generally they follow the European rules, then you've got to make certain that non-EU governments should not have access to the data. And that's one of the issues if you're storing, for example, in China or the United States. And then also European governments should be able to have access to the data by exceptional need. That's a pretty obvious way of thinking about it. And generally it's the public prosecutors that want it. But something you need to be sort of thinking about, again, within your strategy, your intellectual property strategy, which I really wanted to highlight here. And just moving on to the last slide, we've got a few more minutes left here. And we're talking about lack of vendor lock-in. I think a few of you are members or you're following what's going on with the DNA Storage Alliance, who are starting to develop, thinking about standards here. And they're working with the one of the more known standard organizations. What you've really got to think about is if you're participating in these standard setting organizations, then obviously it's great because you can certainly influence the direction of commercialization. And this is well known from the telecommunications and the ICT sphere that the big companies are sitting there, they're pushing for their technology to go forward. Now, participation in standard organizations generally does not require an automatic grant of the license. I know there have been proposals to say, well, if you are in their room, you have automatically agreed to giving everybody a license. That is not currently the case, though there is some people who argue it should be the case. What you do agree to do in every case is that you agree you will give a license to the intellectual property that you put into or encourage to be developed in the standard. So that does mean that once you put your technology forward, then you cannot have an exclusive relationship any longer. You can ask for money for the relationship, a royalty if people want to use your license. But you cannot say, we are the only company that is able to implement this standard at all. other companies have to be able to have access to this standard. So something to be thinking about before you think, if I put my technology in there, I can get some pretty exclusive rights. Yep, you can get some pretty good commercial rights, but you cannot get you cannot get exclusive rights. And I think that's really important. The other thing to think about is if you are putting your technology into the standard setting organizations, the moment it goes into the standard setting organization, it becomes public knowledge. So you need to have the patent applications on file before you actually communicate your technology to the standard setting organizations. I think that's something that needs to be thought about. And yes, big companies are doing this. Big companies are filing patents before they actually go to the big standardization meetings. So one last thing I want to talk about, I was asked to talk about, what about publication? You know, I'm an academic, I've got to keep my publication record up. Can I actually also file patents, publications as patents as well? The answer is quite clearly, you can do it without any problem. And just to give you an example, this actually came from the European Bioinformatics Institute out of Cambridge, or just near Cambridge in the UK. And you'll see here, this was by a couple of people, some of you may know, Nick Goldman and Ewan Burney. This was published in Nature in 7th of February 2013. And let's just go down here. When was it actually filed at the European Patent? Sorry, this was actually filed in the US Patent Office for reasons that are no longer exist. And look down here, this was actually filed on the 1st of June 2012. And so what you can easily see that between June and February, they obviously finalized their publication here. So they got this very good publication here. Plus, they also got this patent. This was the international patent application that was published. It has actually been granted in the meantime, and it's to my knowledge, one of the earliest patents that's granted. Because what was really interesting was what happened here with Harvard University. And Harvard, by the way, was one of the companies that is highlighted in Lluís's presentation. This was from Science Express. Just look at this date here. Where's it got to? 16th of August, 2012, against the 1st of June, 2012. It was clearly sort of hanging in the air what was going on here. What I can also tell you is that they also, the Harvard people also filed a patent application, and yet the European patent, or the EMBL patent, was actually earlier filed. So EMBL have got the patent application presented. During the course of that prosecution, one patent application from a US medical institute, Mount Sinai in New York, was found. Interestingly, though it was quite relevant to what was going on in this little project, the Mount Sinai people had not decided to continue that patent application. So essentially, there was no issue that had to be followed. So last slide here. Think about the valorization strategy, the commercialization strategy. Where are you on this? Are you going to be on this scheme? Are you going to be licensing? Are you going to be collaborating? Some of you are spin-outs. Could you even be selling the patents, or licensing them out to other companies? These are all sort of things that you need to think about. They really do reflect your licensing strategy. Sometimes we write claims differently if we know that the patent is going to be sold, or we write licensing claims that are really relevant, not to what we are doing or what the company is doing, but really relevant to what potential licensees must be doing. So the protection strategy: identify the innovation, DNA constructing algorithms, codecs, instrumentation, data, determine the best presentation, could be copyright, could be trade secrets, could be patent, and think about the valorization opportunities. I'd like to go into this in more detail, but we're right at the end of the presentation. Let's take time for questions and answers. Thanks very much indeed, and I hope I've given you some food for thought during this. Back to you, Jerome.
Thank you very much, Robert. Very, very interesting presentation, very enlightening. Yes, we do have a few questions already in the Q&A. So anyone who wants to add more questions, feel free to just use the Q&A down here. But I'm just going to read the first question, and I think it's related to your presentation, Robert, with regards to a codec. So regarding a codec, can we patent a pseudo code or the full running code?
So the point about it is you cannot patent the code at all. the way that we try and file the patent application for Codex is that we use this somewhat old-fashioned flow diagrams that you see, not just pseudocode. We found it much easier to explain it to the patent office how the idea is working with just blocks, with the not with pseudocode, with blocks, showing it. We might put the pseudocode into the body of the description, but quite frankly, it probably doesn't add much, and it probably just expands that description. You do see patent applications with 20, 30, 50 pages of pseudocode, and actually anything above 30 pages, you actually have to pay extra fees at the European Patent Office. So if I go back to Codex, yes, DNA storage system, codec for it is patentable. Think about writing it in flow diagram. If you can get that sorted out, you don't need to file the pseudocode.
Okay, thank you. Just another question from my side for now, as you know, we're waiting for more questions to come in. You basically talked about patents a lot, of course, and of course trade secret and all that. But in terms of patents, what is the cost of a patent typically? Can you tell us perhaps, Robert, again about where we stand, and for young startup companies wanting to strategize patents, you may want to have a few patents, but what is the cost, and how does it evolve over time?
Yeah, so that's a really good question. So basically, the costs is obviously the attorney's time if you use an attorney. Yes, I am an attorney. I know I'm an attorney, but I would really encourage you to use an attorney because they know how to write patents. And certainly VCs, when they see self-written patents, tend to be turned off because normally they've got lots of holes in them. Even if you're using a large language model, by the way, be really careful about large language models. If you put your confidential information into a large language model, you may well find that you no longer have a novel invention. Just be careful very careful about that. There are some tools out there that claim to be able to provide right patent applications. They tend to be quite expensive at the end of the day, the best tools. It's not just getting the cheap, $20 a month, the ChatGPT subscription. So the attorney fees depends a little bit. If you can provide a really good description, maybe 3,000 to 6,000 euros, something like that, for the initial patent application. Then you've got the official fees. At the European Patent Office, there's some great reductions that they will give you for smaller companies and micro companies. Unfortunately, they don't provide fees at all. Attorney fee reductions. There are some public programs that will help you file patent applications. The EIC has no objection to you using their funds for filing patent applications. If anything, they probably encourage you to file more patent applications. So once you've done that, then you've got the next stage. Okay, I've got my European patents here. My next stage that I've got to do is think about outside of Europe. I would very much encourage European companies to file in the United States. It's not sufficient to file in Europe at all. Hopefully within that 1 year where you've got the time to do it, you will have feedback from the European Patent Office to tell you how good the invention is, so you know whether it's worthwhile. Whether you then go and file in China, Japan, Korea, and something like that, that is very much a decision that you have to make. And I would only seriously consider it for your really, really strong patents, or where there's a particular issue that you need to address. For example, you may be collaborating with a Korean company, so obviously Korean patents may be important or something like that. But really think about doing it like that. So, and the US patents, it depends a little bit. 4,000 to 6,000 euros would be quite typical on top of that. And then you've got the current costs for filing, for the prosecution, for the dialogue with the patent attorneys. So there's a bit of a ballpark figure that you will find, which is that some of the bigger companies spend about 10% of their R&D budget on patents. So if your R&D budget is, 3 million, you might be thinking about spending in total 1,000. That sounds a lot, but over the years it will ramp up because you've got annual fees to pay. There's also a statistic around the place which suggests that companies that are on the stock exchange, for example, file about 1 patent application for every $1 million spent, or €1 million spent of research and development funds. So if you've got 3 million on R&D, maybe that's 3 patent applications. Probably for a startup, you should be thinking about a little bit more. to be absolutely honest with you. There's you can't then say, file 6 patent applications and then say, 6 patent applications, I'm worth 6 million. You can't do it in reverse at all. But just to give you a couple of ballpark figures, and obviously your first year, if you've spent 3 million the first year with 3 patent applications, what have I talked about? Maybe 30,000 euro. That's not 10%, but it will start going up over the years. I don't know if Lluís wants to mention a couple of the programs the EPO.
Yeah, that was very good point. You had good transition to go to Lluís, and what the EPO can offer. Perhaps you did mention support on in your case and early stages, but perhaps the EPO has got a few things to provide as well. Oh, you're on mute, Lluís.
Absolutely. I already pointed out to some of this or part of this support. There's a fee reduction scheme for SMEs and micro entities that the EPO offers. You need to look into it because it's different types of fees that are reduced 30% if I am not if I am not wrong. The one thing that I also would like to highlight is that you have to think well, and I'm sure that you will, about your filing about your filing strategy. The EPO is extremely quick at providing a search report. I think it's about 6 months, rule of thumb, 6 months, where you really get very certain information about what is the prior art that is relevant to you for you, and on that basis you can then decide how to proceed. I'm saying this in the context of fees and patenting costs because it is there the moment where you can have a really well-educated decision on whether it's worth to proceed for which type of scope and in which markets, obviously, you want to go, as Robert said, Europe only, US, and so on. For the fee reductions, look into it. For other services, and that's also something that I wanted to say, or listening to Robert's intervention. The EPO also offers completely free of charge something which is extremely useful. It's called the Deep Tech Finder. I'm going to put it in the chat, and I ensure you that this is not a sales pitch again because it is free of charge. I posted a long link, but it's going to lead you directly to the dashboard. In the Deep Tech Finder, which is constantly expanding, where you will find, and also DNA digital storage will be included in there, is relevant information, pre-digested information on which type of startups and this is extremely important, and also investors are active in your technical field. So I can show you, if you allow me, Robert, quickly, how it looks like.
Yeah.
I think that you see.
Yes, that's correct.
I think that you see my screen. What you see here, it's just a query. It doesn't matter which query now. You will need to go and play with the filters for countries, for technical fields, whether you want to look at pending at companies that have pending applications or granted applications. This is something that you need to play with. But if you go to any of these, what you will find is even zooming in innovation ecosystems, for example, here in the Netherlands, and you can see for each of these companies the type of patents that they have, but also you do not have full information for all of the companies, but for example, this one, which I just picked up like this, you see where are they getting their money from. This is public information, of course, from Deal Room, but also which type of funds are investing in there, which can help you find a proper investor, not only for your technology developments, but obviously for your IP strategy. I could continue, but I don't want to continue in there. There are other resources that the EPO is offering, like the technology platforms. it's worth to go around the links that I posted and then yeah, see how they can support your IP strategy.
I guess we'll be sharing all the links publicly as well, along with the presentations. That's fantastic. Thank you, Lluís. I have now perhaps one wrapping question, which could involve both of you now somehow. Of course, you talked about trade secret versus patent, and of course, trade secret is potentially unlimited as long as you keep the secret. It's fairly cheap, apparently so as well. But of course, I remember one of the first interactions I guess we had with the EPO and a cartography in Munich was about, I think there was a last slide saying that, you get more investors potentially if you have a patent application. So at what stage, so is it true? At what stage, you have, the patent, but the strategy also makes sense. So could you perhaps comment on that, other review, I guess, on that topic, trade secret versus patent, and when and how?
If I may give it a shot, Robert, or just an initial shot, because it's a very interesting, it's a very good question. We have published, and we continue published in the context of the observatory, studies on different technology sectors, and this is a conclusion that really comes up regularly, inevitably, always. Companies that have, and I'm going to say, a coherent IP strategy have, I don't want to say infinitely, but much more chances to raise funds than those that do not have a coherent IP strategy. If they have patents, the chances increase. We can look at the studies. There's no time now, but it can be quantified. If on top they have other forms of IP rights, trademarks, etc., and that's why I insisted a coherent IP strategy, then the chances increase even more. Put it simply, it's a way of building assets to your company. Just like you could have buildings, machines, know-how, it's a way of building technology assets, and of course this increases the value of your company, and of course this increases the chances that you have to raise funding. Sorry, Robert, I hope I didn't jump too fast.
No. And thank you very much indeed for pointing that one out. I would have actually mentioned it as well, that there is this rather interesting study from the observatory exactly on this. And I just wanted to add one other thing on this. Just think about venture capitalists who get your pitch deck. One of the things they'll often look at is they'll just Google and maybe in Espasnet and see how many patents have you actually filed on there, because that's a sign of a good, well-managed scientific process. And it's not just about patents, but it's getting that strategy right and really understanding where you are in the business. We haven't had time to talk about freedom to operate today. We haven't actually had time about actually licensing in detail today. But those are some of the things that you really do need to think about. So it's been a great presentation. It's been a great presentation by Lluís. I hope mine gave food for thought and will give you some interesting ideas about where you might want to be doing your patent strategy. And I think Isabel wants to me to detail up, go into a little bit more detail on this. And so I guess we'll be working together in the next few months. Thank you.
Thank you. That was fantastic. Thank you very much all for your time and for the great presentations and discussions. So I think it is time now indeed to close the session. So yeah, thank you very much, and we're looking forward to seeing the new, so the presentation will be available online, as I mentioned earlier on, and we will also be sharing extra resources through the website and various roads. Thank you very much indeed. Talk to you soon.
Thanks very much indeed. Bye-bye.